Before we jump into today's conversation, though, I'd like just to introduce Simtai Consulting to those who are not familiar with us. And if you are not, Simtai Consulting was founded in 1998. So we are a 23-year-old IT consulting firm, and we are one of the leaders in the space across the region. And in a nutshell, people often ask, what does that really mean? In a nutshell, what we do is we help organizations to resolve business challenges using technology, in a nutshell. And everything we do these days revolve around technology, especially in light of working from home and the global pandemic that we find ourselves in. And we're just helping organizations to get to a place where they can execute effectively with a reliance on technology. There are four main business units across Simtai Consulting. There is the Transformation, Assurance, and Compliance business unit. There is the Data Privacy and Protection business unit, Cybersecurity and Cyber Services, and Risk and Data Management. I won't necessarily go through what all of that means, but just in a nutshell, those are some of the services that we offer. Now, to the meat of the matter, and it is, well, since the enactment of the EU GDPR, that was all the way back in 2016, we've been, as a country, Jamaica, we've been on a course to join other Caribbean nations to model and implement a similar framework for protecting citizens' privacy and personal information. And that is especially important in the age of social media and the Internet of Things and this very connected world that we're living in. And we see, the Googles of this world and the Facebooks and the Instagram becoming custodians of lots and lots and lots of data. But also local entities, when you think about your banks and your credit unions and some of our public sector bodies, RGD and so on, the masses of information that they're collecting, it's vast. So there needs to be a framework around the protection of that information. So a part of the act called for an appointment of an information commissioner. And in December of last year, Jamaica appointed its first information commissioner pursuant to the DPA, and that became effective in December 1 last year. And it outlines, some of the broad powers and responsibilities of the Office of the Information Commissioner. And we now find ourselves in what we call the, an implementation, a 2-year implementation phase. So joining us today for the conversation around operationalizing the Data Protection Act, we have the Information Commissioner, Celia Barclay, who runs the Office of the Information Commissioner. And we are also joined by Joaquin Murray, who is the Chief Technical Director for ICT in the Ministry of Science, Energy, and Technology. Ladies, welcome to you both, and thank you very much for joining us.
Thank you. Thank you for having us.
Excellent.
Morning, everyone. Thank you.
Great. So, Commissioner, let's start with you. So, congratulations, firstly, on your appointment. You're sitting in the hot seat, and there's a saying that says, "Heavy is the head that wears the crown." What have the last 2 months been like for you?
The last 2 months have been interesting as well as exciting. There has been quite a bit of activity, particularly having regard to Jamaica observing Data Protection Day last month. So essentially, what we have been doing is having meetings and discussions with respect to the operationalization of the office, as well as trying to capitalize on that opportunity that was provided by Data Protection Week to shed some light on what the area concerns and certainly to increase public awareness in terms of what the rights and obligations are under the legislation.
Right, got you. And that is obviously important groundwork for some of what is to come. So your appointment signaled the beginning of a 2-year implementation period. Yes. Can you tell us what will be happening during this 2-year phase?
All right. Well, if you look at the legislation, and just to clarify for some persons, because there are those who are of the view that there's an ambiguity in terms of the provision. So Section 76 of the legislation provides for a transitional period in which data controllers are given the opportunity to bring themselves to a state of compliance with the legislation. So this is a time within which you're to take the necessary steps to prepare. And during that time, it says they may not be prosecuted for not complying with every single provision. So of importance is the fact that the reference to time in that provision is to the earliest appointed day. And so we know that the transitional period has kicked in because even though the Act allows for there to be different appointed days in which different sections come into play, it speaks to the transitional period counting from the first of those days. So not every section of the Act may be in force as yet, but that transitional period does start to count from December 1, 2021, when I was appointed, which is the first published date. Now, it's also important to note that the provision is for the controllers may not be prosecuted. It is not shall not be prosecuted. So it is imperative that persons still take steps as far as possible to try and be compliant with the legislation, because technically on a strict interpretation of that provision, a prosecution is still possible.
Yes.
So what is it that we require to be done? On our side, as a regulator, we will be taking the necessary steps to operationalize the office. So we'll be building it out, everything in terms of recruitment and training of staff, putting the necessary systems in place to allow us to carry out all our functions. And this is from the registration of the data controllers to, of course, monitoring their compliance, being in a position to receive and process the complaints, and of course, to investigate and prosecute where necessary. And putting the systems in place to ensure that that can be done both effectively and efficiently. But on the side of the other persons that are affected by the Act, data subjects, data processors, data controllers, what we're looking at, as we said, is for them to get ready. So what are they getting ready for? Number one, get ready to register. Because while controllers are not able to register at this point in time, because the system is not yet in place, as soon as the system is available and the time has come for them to register, we will be moving as fast as possible to register as many controllers as we can in order to put ourselves in the best position to monitor. And so the controllers have to be ready for us. That means getting together the necessary information that registration requires. And there's a long list of what that consists of. So you have the very basic information in terms of the name of the entity, the type of entity. If a data protection officer is appointed, then of course, the name and contact information of that data protection officer. But then in addition to this, there is a need for you to provide information as to exactly what personal data is being processed by the controller. And if you look at the definition of personal data under the Act, you realize that it's very wide. It consists of just about any type of information by which an individual can be identified. So it's from our simple identifiers such as your name, your address, a phone number, an email address, to things like your biometric data, your DNA. It includes other attributes and characteristics that, together with other information, can be used to identify you. So you're a member of a particular organization, that's considered personal data. You have a certain biological relationship to another individual. You're the son of John Doe or Mary Jane. That's also considered personal data. Other things such as your voice, your image, how you carry yourself in terms of your gait, it is very far reaching. And so data controllers will now have to be able to identify each type of personal data that they are processing, but also identify and outline to us why this data is being captured, what purpose is it serving, how is it going to be processed, and most importantly, to whom is this data going to be disclosed? And so you recognize that that is a process that is not something that you can complete overnight. In fact, for many organizations, that they may lack the technical expertise in-house to do this. And so what we recommend is that persons engage the expertise. It may be that you have to put out some funds at the outset There are persons that provide, for example, data privacy impact assessments that can help you to identify the vulnerabilities in your organization. They can map your process for you and advise you as to whether or not you currently meet the requirements, and therefore put you in a position to be able to take steps now to correct that. What you don't want is to get to the point where you need to register. And as soon as you register, you realize, but I'm non-compliant.
Right.
So we're
Yes.
encouraging persons to start that process from now. So you have a 2-year period, the clock is already ticking, get moving on that. When we
And
say
just to pause a little bit there, Commissioner. So on the point of registration, so once an organization registers, who will have access to that information, and will the Access to Information Act also apply to that information?
It would. It is a register. It is being kept by what is essentially a public authority. And so a data subject who wishes to know whether or not a particular entity has registered as a controller can ask for that information. So it's in the interest of the controller, if you want to build trust and confidence in your clients, your customers, for you to get registered so that they can see, here's an organization that has a vested interest in protecting my privacy. So I don't have to worry as much in dealing with them. Not to say that they're not risk, but at least, you're dealing with a conscientious entity and someone that is looking to comply.
Right.
Also, in terms of readiness, one of the things that I am definitely promoting and encouraging is that persons also get ready, not just in terms of to register or to comply with the standards, but get ready for enforcement. And what I mean by that is this. Even if you have everything in place and you register as a controller, you have taken the necessary steps to ensure that you can comply as far as possible with the standards. But we have seen what is happening all over, and anything is possible. So at any point in time, you can find that there has been a breach, or you end up contravening a particular provision. What then? If it is that you are prosecuted for a breach, what will you do? I've had persons so far who called to say the penalties are steep. And in the context of a Jamaican economy and the value of the dollar, they may appear that way. But I can also say that by comparison to other jurisdictions, some persons would say the penalties are significantly below the average.
Minuscule, yes.
As I said, the complaint has been, the way one person put it to me was, if I get penalized today, my business goes bankrupt. Because they can't find $2 million or $5 million or $7 million to pay. So what are you going to do? Are you going to wait until a situation arises? You are now in breach, you're faced with a penalty, and you throw your hands up in the air? What we encourage is put provisions in place from now. You have 2 years, anything is possible. Rework the budget, sort out in terms of what arrangement can I make to ensure that in the event that I have an issue, my business is in the best position to meet what that requires. So if it is that you have to pay a penalty, you have some funds reserved that you can tap into. And you also have to be aware that it's not just about the penalty aspect in terms of fines, because the legislation also provides that if a data subject is affected or distressed or suffers some kind of damage as a result of that contravention, then you may owe a liability to compensate that subject as well. So it is not a matter to be taken lightly. It is something that controllers have to be serious about. And as I've said in other fora, I encourage persons to start the discussions in terms of how can I use the word insure myself against this liability. So, there are other forms of professional insurance. Maybe this is a time where, as a group, whether particular sectors or a conglomerate of entities, may need to approach insurance companies to say, well, here is something, it's fairly new, there's a worldwide movement towards this. We see what the liabilities have been in other jurisdictions. We know what it can be in Jamaica. What can you do to help us? It might not be around today, and I don't know. I haven't investigated that aspect of it. But if it's not, it is something that perhaps with the right movement and promotion and persons, having the discussion in 2 years or more, you can have that kind of protection, which will assist you. And certainly, again, it goes to the confidence that you build in your data subjects, because what you want is for persons to be reassured that not only are you taking steps to protect them, but in case they suffer as a result, it might not be of your negligence, but just of the wrong thing happening to the wrong person, there's something that they can benefit from in terms of compensation.
And I suspect if there are any insurance professionals in the webinar, there are almost 200 people here, then you've just given a great business idea to some of them. But it sounds like right. It sounds like there's a lot happening, both or a lot will be happening both on the side of the Office of the Information Commissioner in terms of getting ready, but also there's a lot to happen for organizations just to really get their houses in order. I want to shift gear a little bit, Commissioner, and talk about the regulations. So we know that with the introduction of any new act, there is an accompanying set of regulations. When is the expected rollout of the regulations to guide implementation of the DPA?
Well, Ms. Murray, I know, has been working on that together with the ministry, but I can tell you that we are very conscious of the fact that the act is nothing without the regulations which give it teeth.
Right.
And
yes.
so there is a move to ensure that the regulations are promulgated as soon as possible, and particularly having regard to the fact that we see what is happening in relation to, for example, NIDS, where there's a move to swiftly implement that. And as that also would be essentially and potentially the island's largest data controller, then of course we want to make sure that we are in the best position to be able to regulate that organization as well. So the act has been reviewed in terms of identifying the different sections that require regulations, things like the prescriptions that have to be made, whether by the minister or by myself. And it's now at the stage where we're looking towards what exactly needs to be drafted and what those provisions would be. But perhaps Ms. Murray can shed a little more light on that.
Okay, Ms. Murray.
Sure, thank you, Commissioner. Right, as the Commissioner indicated, we are moving apace in terms of trying to develop the regulations in relation to this. We as a ministry would have received some support from one of our international organizations in the form of a consultant to assist us with that. So Section 74 of the legislation calls for or empowers the minister to make regulations to support the operationalization of the legislation. And we are going through to make sure that, or to ensure that those elements of the act that require regulations immediately are actually treated with, because not every rulemaking power is going to necessarily be addressed in what we would call a first phase. But those with respect to safeguarding sensitive personal data, which has a different meaning from just personal data. And for those persons who would have looked at the legislation, you would note the distinction. So there are rules around that have to be put in place by the minister. Matters relating to the disposal of data and or the retention periods. Of course, there are fees and fines that are mentioned in the legislation, which will have to be treated with as well. And generally, and importantly, there is the issue regarding the process for persons who are aggrieved by any decision that the commissioner may make in carrying out the office's duty. For those persons who look at the legislation or who have looked at the legislation, you'll notice that there is an appeal process to a tribunal. And so our intention is certainly to have that those regulations rather, or maybe an omnibus regulation. We'll see how that goes. But to have that regulation in place during the course of the upcoming legislative year, which would start 2022 to 2023. So we want all of that settled during this 2-year transition, so that everybody will be ready. and everybody will know how it is that they're going to inform themselves and prepare themselves for what is to come.
Okay, excellent, good. So it sounds like you're moving, or the intention is to move relatively quickly, Ms. Murray. And staying with you, a question that had been asked of us by a client, and it is really around the definition of data sets. So there are some nebulous terms in the Act, and not everything is defined and black and white. So the question is, will the development of the regulations also include a definition for small and large data sets?
So absolutely. So what we're doing is ensuring that that any area of the legislation that requires greater detail or further explanation so that persons can understand the legislation, that will be incorporated in the regulations. Bearing in mind that not everything will be treated within regulations. There are some things that we believe from the office's perspective, they may issue guidelines, directives, clarification around. So it's not that every single thing is going to be addressed in regulations, but those matters that we think for the purposes of understanding or for providing further clarity on a point that is in the primary legislation, then that will be instructive. But what we've seen is that the approach that has been taken certainly by data commissioners and or information commissioners in other jurisdictions is that the office tends to guide through guidance notes, through directives, etc. And that I think is going to play a great part in helping data controllers, data subjects, data processors to understand the legislation.
Okay, and I guess finally on that piece, as was the case with the development of the Act, will the development of the regulations also be a consultative process in that organizations, well, in fact, anybody will have an opportunity to provide feedback into the process?
So regulations are not necessarily as open in their development as the primary legislation. I think everybody on this, most persons on this platform would have realized that the Data Protection Act did go through a period of consultation once it was tabled in Parliament. Our legislative process doesn't open up the development of primary legislation or subsidiary legislation to the public at large.
Yes.
But to the extent that the matter is considered extremely critical, then that can be done. The minister has powers within the legislation to make these regulations, some of which have to be tabled in Parliament, others don't. The office has powers as well to make regulations or rules, etc. And those sometimes can be done within the context of the office itself, or in consultation with the minister. So there are different ways for different things. And so I can't say that we're going to necessarily go public with the provisions of the regulations, but for those matters that certainly need tabling in Parliament, then that would be the opportunity for comment.
Okay, excellent. Thank you. Commissioner, just jumping back to you and piggybacking on something that Ms. Moore just said around broad powers of the Office of the Information Commissioner. Would you mind just talking to us a little bit about some of those powers? What are some of the broad powers or the broad important powers of your office?
All right, so in order to look at what our powers are, I'll first look a little bit at what the role of the office is. So our primary role is, of course, to monitor compliance with the legislation. But in addition to that, or in order to assist that process, we also do an evaluation of annual data impact assessments that are required to be submitted by each registered data controller. So those will be submitted to us. We will review them, determine whether or not the provisions that are in place are sufficient, and of course, offer directives to the controller as to what they can do to improve their processes or their systems to ensure greater compliance. In addition to that, we will, of course, accept and investigate complaints that are made by data subjects. And so in that regard, we can look into a complaint, see whether or not it is justified or valid, and of course, take the necessary steps to have it remedied. Now, this includes the issue of enforcement notices. So depending on what the alleged breach or contravention may be, the commissioner does have the power to offer certain directives to a data controller. So we can, depending on the circumstances, direct a data controller to cease processing of personal information altogether. We can direct that it be ceased for a particular period, or it may be that only a part of the information needs to not be processed, or a particular type of processing needs to be stopped in relation to that subject or that particular information. So it varies, but we do have that authority in terms of directing what steps need to be taken to ensure that the data subject's rights are being upheld. In addition to that, we also assess and determine what matters will fall within what the Act calls specified processing. So there are certain type of information that the minister may determine should be processed in a particular way. Once there's an order that speaks to that particular type of processing, which is specified processing, then it would be for the commissioner on each occasion when something arises to determine if a particular process falls within that category or not, and how it should be treated with. There's also similarly processing for a special purpose, because in some cases there might be a particular reason why a type of information needs to be processed. And so we would also do those determinations as well. But most importantly, there is prosecuting non-compliance with the Act or contraventions, any breach of the standards or of other rights that are provided for the data subject. That is something that, together with the Office of the Director of Public Prosecutions, we can pursue, or with her leave, then we can pursue. So the whole aim is to ensure that not only is there a system in place for protection of the subject's rights, but there's a system in place to ensure that where it is not protected, then it is penalized. And we have essentially the powers and authorities necessary to allow us to do that.
Yeah, one of the first things you mentioned is the review of the DPIA, and that's an important tool that organizations will be using or submitting to your office. Will there be a specific platform to share DPIA or, well, any incident or breach reports that you can think of in the same way that we will do for TTR, under AML reporting, for example?
Well, what is considered right now, and we're still in the development phase, so we haven't determined any specific system as yet. But what is considered right now is, in order to ensure optimal efficiency, we want to build an office that starts out, I would call it, ahead of the game, or certainly in the game. So we're hoping to, as far as possible, be able to digitize our documents and information from the start, as well as to automate as many of our business processes as possible. And so in order to facilitate that, one of the things I'm considering, and certainly with the support of the ministry who is assisting, is allowing for certain processes to be conducted via online transactions or online interactions. And so when we look to build out the website for the office, we're looking to see as far as possible how that website can be used to facilitate not just the provision of information to the public, which is also a part of our mandate, but to facilitate access to the services and the functions of the office. So for example, we're considering online applications for registration, where rather than coming into the office with all the paperwork and document, we'll actually have a platform user interface where you can input the information, you can upload the necessary supporting documents, the application is submitted to us, and we can review and respond by those means. In a similar way, we would be looking to have that sort of interface with persons who wish to make a complaint. So persons can log on to the website, input their information, put in the necessary supporting correspondence or other documentation that they believe evidence that there has been a breach, and we take it from there. So for the data protection impact assessment, the same thing is contemplated, where as far as is possible, persons would be allowed to submit that information to us via our online platform. And we would be able to also do a review and respond. It doesn't mean that from time to time, for the purposes of our review, we might not have to come out into the field, whether to ascertain things for ourselves or to check and confirm that the information presented is accurate. But certainly in terms of being able to facilitate the receipt of the assessment, we would be looking to do that in that way.
Got you. And I guess still just staying on the DPIA, is there a recommended format for the DPIA for submission, or is that really left up to each business to decide how they want to submit that?
For consistency, while we recognize that businesses are different and what information they process and how they process it will vary, there are certain commonalities. And so for consistency, what is contemplated is that there would be a sort of standard form that could be used. And it may be that for different sectors, we have different standard forms that would apply. But in any event, even if there is a template set out, we would definitely want to leave it open for controllers to be able to submit any additional information that might be relevant to their assessment that would fall outside of a form that is provided. But we'll be guided, of course, by international good practices and what obtains in other jurisdictions and what we see have worked in terms of developing that form, and certainly disseminate it to the public so that it's accessible to everyone.
Got you. All right, great. All right, so one of the things that seem to be confusing some people is really the distinction between the data controller versus the data processor. So perhaps we can talk a little bit about the distinction between the two, and probably more importantly for some on this call, where does liability fall?
All right, so the data controller, when you look at the definition, and this is one of the terms that is actually defined by the Act, the data controller is essentially the decision maker. So this is the person or entity that determines what data is captured, where it is captured, how it is captured, by whom it is processed, right? So it is anybody that is making those decisions as to the processing of personal information. But it also includes anyone that is processing personal information pursuant to any statute. So most of the public authorities would be data control. In fact, all the public authorities would be data controllers naturally. So the processors now are those persons who have been engaged by the data controller to carry out certain processing functions. So know that a data controller may be processing the data for themselves in-house, but where it is that we distinguish the processor is where you have a non-employee, someone who is not your direct servant or agent that you have engaged to deal with this data in some way for you. So your data processor is that external person or company or whoever that is assisting you, whether in terms of collecting the data, how it is stored, being able to retrieve it, analysis, modification of the data, somebody that you engage to dispose of the data when you no longer require it, all the different aspects of processing. If any of those are done by a third party, someone who is not an employee of the data controller, then that third party is a data processor for the purposes of this legislation. Now, how you can look at it is, simply put, the data controller is the person who essentially possesses the data. And so they have the duty and they will get the damage. When you look at the provisions in the legislation that speaks to the obligations, it is an obligation of the data controller. So you choose to engage a processor, but in so doing, you do not give away your responsibility. You do not relieve yourself of any burden. The penalties that are imposed by the legislation are imposed on the data controller. So it is now for the data controller to ensure that in selecting a processor, they're being diligent and they're selecting somebody that they can rely on. Because at the end of the day, if there's a problem with the processing and if somebody is affected, the liability is going to rest on the data controller.
Got you. An important part of all of this dynamic, and it sounds like a bit of a spaghetti soup, right? But an important part is really the role of the data protection officer, really just keeping all of the different parties accountable. What would you say are some key considerations for appointing a data protection officer? I know the law talks about a suitably qualified individual, but just from, even in the absence of the regulations defining what suitably qualified means, what would you say are some key considerations when appointing or looking to appoint a DPO?
Well, certainly the regulations will flesh out as to what suitably qualified means. And what I anticipate or foresee is that it will take into consideration both the qualifications in terms of necessary certifications to carry out the functions, but as well as any experience that persons may have in the area. It may very well be, and this is something that we'll have to look into, that courses will have to be introduced to train persons in that particular field, because certainly we would want to develop a market in that area that data controllers can pull on, because we recognize that because of the varying sizes and operations of entities, not all data controllers may be in a position, for example, to have a specific person internal who can operate as their data protection officer. And so you may have to end up with a regime in which persons can pull on the services of independent contractors and professionals in order to carry out that function for them. So what you are looking for is not just somebody who has the know-how to assist you in terms of monitoring your risk, someone who is familiar with what the data protection standards are and certainly the other requirements of the Act, somebody who will know on a very intimate level what your processes are, and so they are able to pick up on whether or not they are consistent with the requirements of the Act. But certainly as well, somebody that you can trust to be open and honest with you. And this is why the Act speaks to the data protection officer being an independent officer.
Yes.
So this is somebody that there's no express prohibition against you appointing an employee of the data controller as the protection officer, but it's very clear that that person cannot have any role that would in any way conflict with their functions as a DPO.
Right.
So you can appoint somebody who himself or herself is processing personal information, because then if
Conflict
there's
of interest.
an issue, something they did wrong, exactly, they might not bring it to your attention. So if you choose, whether you choose to appoint an employee or appoint an external person, what you want is somebody that will be very upfront in pointing out to you when there is an issue so that you can take the steps to address it. Because the obligations of the data protection officer in terms of what their responsibilities are very simple under the Act.
Yeah.
Firstly, and primarily, I would say, is to assist the data subjects. That's their first priority. That's the most important thing, because the whole legislation is framed around protecting the rights of data subjects. And so persons have to be in a position to exercise those rights. So where a data subject is making a request for certain information or is complaining about certain contravention, the DPO is there to ensure that the data controller does not play deaf, dumb, and blind. They're responsive, right? And they uphold those rights. It's also for the data protection officer, as I mentioned earlier, to ensure compliance with the legislation. But how are they required to do that? The Act goes further to say this is done by firstly notifying the controller. That's the job of the DPO, to let you know that there is an issue.
Right.
The duty now to remedy the issue remains with the controller. So I've been in discussions where persons appear to have been of the view that once you appoint a DPO, It is the DPO's job to make sure that you're compliant. And if you're not compliant, then it's their responsibility and the liability is on them.
Yes.
That's not the case. The liability is with the data controller, and the job of the data processing officer is to let that controller know when they are not meeting the requirements of the legislation. And then further, if it is that having notified the controller does nothing, or what the controller does is inadequate in his view, then he has a duty to me, because the legislation says he is now to notify the commissioner if the steps that have been taken by the controller are insufficient. So if the breach remains, if there is no remedy provided, there's no rectification, then the matter comes to the commissioner to be dealt with on a more serious level. So that's the role of the data protection officer.
Yeah, quite an important role in all of this. And I can see why a lot of people would approach it with a little trepidation, if you will. Ms. Murray, I'd love to bring you back into the conversation, and it is really around looking at the spirit of the law, the spirit of the act. So a lot of people reference GDPR because of its far-reaching powers. Now, considering the Jamaica Data Protection Act and the application and jurisdiction, it was the spirit in framing the legislation that it would be far-reaching, and it would also apply to Jamaicans outside of Jamaica or data processing activities outside of the Jamaican jurisdiction. Can you shed a little bit of light on that for us?
I apologize, sorry. So that was a major discussion when the act was actually being considered by the Joint Select Committee of Parliament that was established to review the bill at the time it was tabled. The concern being how we have large organizations, the likes of your Meta, formerly Facebook, and so on, that gather data in respect of Jamaicans and how would they be treated with. And so when you look at, and if persons would look at the section 3 of the legislation, you'll note the applicability of the legislation. So the legislation is applicable to any business or any person, whether that person is a natural person or a legal person, once that person is located in Jamaica. But also, the legislation was, because of the concerns that would have been raised by interest groups, stakeholders who would have commented on the legislation, the bill was actually amended to include what we call an extraterritorial provision, so that the fact that you do not have an established business in Jamaica does not mean that you're exempt from the legislation. And so, to the extent that you provide products and services to a Jamaican living in Jamaica, the legislation applies to you. And that element of the legislation was actually adopted from the GDPR.
Yes.
Because, of course, I think most of us know who are familiar with the GDPR, that the GDPR has an extraterritorial effect in that anyone that deals with an EU citizen or sells products or services will be liable under that under the regulations. And likewise, the Jamaican Act does the same. So it is about whether you are established here as an organization or as a business, and or whether even if you're not established here, whether or not you provide products and services to Jamaicans, and in that regard, the legislation is applicable.
Got you. And I wanted, one final question before I jump to some of the questions that have been coming in the chat. And thank you very much for submitting your questions. A lot of people will say, they've seen a lot of these legislations come into effect, and it's great. But having legislations is one thing, but it's enforcing the legislation that is generally where we fall down. So it becomes a teethless dog, all bark and no bite. What do you say to individuals, to organizations who may believe that this will be another such legislation?
I would be shocked if at this point in time people are still of that view, because, and I see the commissioner turning on our video, because the fact is that that is exactly why we have an office of the Information Commission. It's one of those pieces of legislation that we realize that you really you couldn't operationalize if you don't have an office akin to what is established in the legislation. And so her entire function, or the entire function of that office, or one of the major ones, and she spoke about it earlier, will be about enforcement. And I think what I would say generally about the legislation and people, users of the legislation, data controllers, data processors, data subjects, I know data controllers in particular might be a little anxious about the legislation, but what we're introducing through this piece of legislation is a culture of privacy and protection. And I think people, we're trying to move our data controllers into a phase or a regime or an era where we're saying the data that you process is not your own. It belongs to someone else. And in that regard, you have an obligation to those persons to ensure, as far as possible, because we know that nothing is foolproof, right? As far as possible, you take steps to ensure the security, the integrity, the confidentiality of the data that you process. And so, as indicated by the commissioner, it really is about how we protect the data that data subjects share. And I want everyone, if this is the final word that I might have, to remember that we are each data subjects. All of us are data subjects. So we may be a data controller in one sense, but we are somebody else's data subject.
Yes.
Right?
Yes.
So we have to ensure that when we were looking at this piece of legislation, it's about how can I be transparent? How do I ensure that data subjects feel secure as best as possible, that when they pass their information over to us and that data is being processed for your business, that that data subject is protected to the extent that they can be, and that there is open dialogue with the data subject in respect of what it is that you use the information for. So it's about transparency. And I think if we look at it in that way and consider that we are also data subjects, then we might look at the Data Protection Act less as a problem and more of a solution.
Got you. And thank you very much for clearing that up for us. All right, conscious of time, we have about 10 minutes left, and I do want to get to some of the questions that have been posed in the chat. And some of them would have been answered through some of the responses in this conversation naturally. And I believe the one that Andre Paul Wright asked first was, recently addressed, and it says the GDPR has very heavy fines and is binding for entities that reside or operate outside of the EU. Will Jamaica have the authority to do the same? For example, Google Analytics was found to be in breach and was banned in the EU. Will Jamaica be able to do the same? Ms. Murray? Oh, you're on mute.
Sorry, my apologies. Yes, and that would have been, that question is related to the question you asked about the applicability of the legislation. And as I indicated, it has extraterritorial effect. And so anyone who provides those kinds of services, goods, would be impacted by and would have to comply with the legislation.
Great, thank you. And the one that Gawain asked too was answered earlier by the commissioner around who best fits the role of a data protection officer, what criteria can be used to decide if this person should be an internal employee or an external person. And I think, so Ms. Barclay earlier responded to that one. Another question from Gawain, are you able to estimate when registration of data controllers will begin? Is that likely to be in 2022?
Based on where we're at and the requirements, and because in particular, we're aiming to do that through a system, which is part of a larger business process, I wouldn't rule out a late 2022, but I believe it would potentially be further in the transitional period. But certainly we would be looking to get that on train within the transitional period, because the hope is that by the time the period ends and you get to full implementation, that you already have some data controllers registered.
Mm-hmm. Okay, thank you. Another one from Erica Harris. There is empirical data that cyber insurance increases the operational costs for organizations. If we are to accommodate insurance related to data protection, how can we mitigate to reduce operational costs and encourage use? I think this was in reference to the earlier point around cyber insurance for data protection element.
Well, I'm not sure that is a question for me. What I would say is that it is for each organization, particularly viewing themselves as a business, to do a cost-benefit analysis and determine for themselves what the risks are and whether it is worth it. Certainly, there is nothing in the legislation that compels a data controller to get insurance. It is merely a recommendation for your own protection. And so if it is that a data controller opts not to get insurance because they think, well, the cost is too high and it's going to cut into their profit margin, then certainly that's a risk that they take. But it's just a matter of knowing that enforcement will come. It's a part of the role of the office. You asked a question earlier as to whether this will be a toothless legislation. And I endorse everything that Ms. Morris says. And I would add to that the office is too big and too important to fail. It is not just that the Act provides rights for the protection of each Jamaican. It is that the Act is there for the benefit of Jamaica as a country. We're participating in an international economy, and with or without Jamaica, the world is moving towards data protection. So we have no choice in this matter but to ensure that the rights of individuals to the privacy of their information is protected. And we intend to do that, whether you insure against the liability or not.
Absolutely. Great. Patrick Angling is asking, I suspect we're in the first phase of effecting the DPA. This being the transition period, what are the other phases of the rollout and what are the associated dates for those phases? Either Commissioner or Ms. Murray can respond to that one.
So I would, and I'll be guided as well, but I would say that we're in the first phase because, as indicated, the operationalization of the commission is taking place. Those provisions with respect to the office have been brought into force, and the 2-year begins. Mm-hmm. The other elements of the legislation, of course, will come into play at various points. And as indicated, regulations, we will seek to have, regulations promulgated certainly within the upcoming financial year, 2022 to 2023. And so those things will certainly evolve, my apologies. So the fact is that there is a phased approach being taken, but the key dates, I think, is that 2-year 2023, where everyone who the legislation applies to will have to be compliant.
Okay, great, thank you.
And just to make one point, that there is no difference between private sector data controllers and public sector data controllers. The legislation is applicable to both private and public sector, and the guidelines issued from the office from time to time or the regulations will be applicable to both the private sector entities as well as public sector entities.
In equal measure. That's an important point. Yeah,
absolutely.
And there are lots of questions coming in about the DPO, the Data Protection Officer, and we're kind of running out of time. So we won't be able to get to all of the questions. So I do apologize. What I will commit to is providing responses via email as best as possible. But I want to touch on a couple of the ones coming in about DPO. So it's one of the questions, so Curtis Moxham is asking, are there any legal protections for the person appointed if they give advice that is ignored? I think that's an important one. will take that one? Ms. Murray, Commissioner.
Commissioner.
I can look more specifically at the provisions of the legislation in that regard, but just by my recollection, I cannot think of an express provision that would protect them. However, what I would point out is that, as I mentioned earlier, the obligation is really on the controller. And so once the DPO has given his advice and his recommendations to see, and no, the legislation doesn't even go as far as to expressly say he must provide recommendations as to how to fix an issue. What it says is he must notify the controller that there is an issue. So the duty to fix and how it is fixed or remedied still rests on the controller. If you choose to, well, if the DPO chooses to give a recommendation, then it would still remain at the discretion to the controller whether and to what extent to accept it. But he will certainly bear the liability of the result if he fails to accept it.
Okay, got you. And
I would just add something to that. The legislation does absolve the DPO to the extent that the DPO does what he or she is to do. In fact, where it is that advice is given and not taken by management, the DPO under the legislation is under duty to report that to the commissioner.
Okay, got you.
And I see people talking about whistleblowing. That's essentially the whistleblowing element of it as it relates to the DPO, and which is why the independence, as mentioned by the commissioner, is so important.
Yeah, man, we may need to have you both back for part 2. There are so many questions, really important questions that I'm seeing in the chat that, would love to be able to get to. So with your consent, I'd love to invite you both back. But there's one that I actually want to get to because I think it's slightly controversial, but also important. And I see Jade Hollis asking it, and Garfield Goldburn also asking, and it is really around churches. So would a religious organization that captures names, addresses, and telephone numbers to call person and preach to persons be deemed a data controller? And Garfield's question was, can churches fall under the definition of data controller as it relates to the Act?
Absolutely. Anyone who processes personal data and or sensitive personal data is by definition a data controller. The question, though, is whether or not you have certain obligations under the legislation, and to some extent, nonprofit organizations are exempt. So, for example, a nonprofit organization does not need to appoint a DPO, but you would be considered a data controller, and it's in your interest as an organization to ensure that you take whatever steps, whether you're a church or a club or whatever, to give effect to the legislation.
Great, thank you. Yeah, man, we will definitely have to invite you both back. An hour certainly wasn't enough to ventilate all of the questions and the concerns that are coming out of what has been triggered, the 2-year implementation period that has been triggered. But unfortunately, we are out of time, so this is where we will have to leave it for today. So let me thank both the Commissioner, Celia Barclay, and the ICT Director, Joaquin Murray, for joining us today. We were talking a little bit earlier about what organizations can do to really prepare. And one of the things that we're doing as an organization, Simtai Consulting, that is to offer data privacy training courses. So we do have certified data privacy courses that are internationally recognized. Do feel free to get in touch with us to discuss these in more detail. We have a couple coming up, one in February and another one in March. You can reach out to us at training, training at simtai.com, or you can visit our website. Ladies and gentlemen, thank you so much for joining us. It has been a really informative and educational session. And thank you very much for your participation. Thank you for your questions. We will strive as best as possible to answer some of these by email and on our public social media profiles, so LinkedIn and Instagram. So look out for some more responses that may be coming your way. Again, thank you very much to our guests, Ms. Murray and Ms. Barclay. Enjoy the rest of your day, and thank you for joining us.